Good afternoon, and thank you for participating in today's webinar on Jeopardy Investments. My name is Talia Rivera, and I'm the Director of Private Philanthropy here at the Council and your moderator this afternoon. Today's webinar is designed specifically for independent and family foundations to share what you need to know about the Internal Revenue Code for Section 4944, which is taxes on investments which jeopardize charitable purpose. Before I turn it over to our speaker, I'd like to share a few housekeeping items with you. To access the help desk, select the help option in the toolbar at the top of your GoToWebinar navigation panel. If you'd like to ask a question, click the questions box to type a question for the presenter. If you need to exit the webinar, click the gray X in the upper right corner of the gray webinar navigation bar. And finally, a recording of this webinar will be made available on the Council's website. Now I'm going to turn it over to Suzanne Friday, who is our Senior Counsel and Vice President of Legal Affairs here at the Council on Foundations. Suzanne?
Thanks, Talia, and good afternoon, everyone. Thank you for joining us. So as Talia said, today we are talking about the Internal Revenue Code Section 4944, which is a section that applies strictly to private foundations. This is not the most expansive topic that we could talk about. In fact, it's kind of a narrow topic, but it does come up on occasion, and particularly in connection with foundations who are interested in doing program-related investing, mission-related investing, and that's how we're going to round out the talk today. As you can see in the agenda, we're going to start with some background and talk generally about the duty of the governing body of a foundation and the role of the board and an investment committee if you have an investment committee. I'm going to explain the basic elements of 4944, talk about what the penalties are in terms of taxes that can be assessed, and then exceptions to these rules, which include program-related investing and mission-related investing, which I already mentioned, and an IRS notice that came out a couple years ago, which is provides some helpful guidance. There's my disclaimer. You can read that yourself. And so starting out with some background, the duty of the governing body of your foundation, your board of directors or your board of trustees, your board's legal duties are generally an element of your state law. So you need to know what your particular state law provides with respect to nonprofit corporations or trusts, depending on what form you're at, and then what the duties they assign to your board members. Most states are very similar in that they require a duty of care and a duty of loyalty for your governing body, for your board members. How this is judged is often by using a good faith standard or a business judgment rule. So for example, as a board member, you have a duty of care to act with good faith and prudent judgment when making decisions for your foundation, making business-related decisions, and that includes investing decisions. You can be held accountable if you fail to exercise your duty of care or your duty of loyalty. And duty of loyalty comes into play when you may have a personal interest in something, but the foundation also has an interest, and so your duty is of loyalty to the foundation as opposed to your personal interest. So again, this is provided in your state law. So you look at what's are you as a board member acting in good faith? Are you using a prudent business judgment when making your decisions? Every state, with the exception of Pennsylvania, also has the Uniform Prudent Management of Institutional Funds Act, which is UPMIFA. This would apply to your assets that are endowed, and most private foundations, independent foundations, have endowment assets. So they are going to be subject to UPMIFA, and UPMIFA talks about how you invest those assets and what factors you need to be aware of to make sure you're making prudent business decisions with respect to investing those assets. Now, most states also have written into their law some liability protection for volunteer board members, and I say volunteer because most of the statutes that I've looked at do say that if you are a volunteer for the organization serving as a board member, by law in your state, you will have some liability protection if you've acted in good faith. So even if the decision that is made is not a good one and gets the foundation in trouble, if the board has acted in good faith and generally acted with their duty of care, they will be personally immune from liability on those occasions as a matter of law in the state. Now, if you have board members who are paid compensation, that may affect the liability protection you have, but it varies state to state. So getting a little bit more specific with respect to investments and the board's responsibility with respect to the foundation's investments, the board, of course, has the legal and the fiduciary responsibility for managing the foundation's investment assets. And that cannot be fully delegated. So regardless of whether you hire outside investment managers, the board can never fully delegate its duty to act prudently with respect to investments. If you are hiring outside investment managers, which is perfectly fine, the board's duty is primarily focused on that decision who to hire, and what kind of fees you pay and what their experience is, and making sure that they are qualified to make those, to manage your investments. But again, that can never be fully delegated away. You cannot, in a contract with an investment manager, write into the contract that the investment manager takes 100% of the responsibility if bad decisions are made, because there is always an element of responsibility that's assigned to the board. UPMIFA, again, provides some guidance related to governance of endowment investment assets, including how you can determine what your spendable amount is. So no longer do we have to use the rule that you have to maintain the historical dollar value of your endowment. UPMIFA, which is an updated version of the prior law, allows more flexibility in how you determine your spending amount. Of course, private foundations have minimum annual distribution requirements that are going to factor in very closely to how much you spend, but there is also some guidance in UPMIFA on how you determine what your spendable amount is. So we recommend here at the Council, if you don't have one already, that a foundation develop and adopt an investment policy statement. And this is something, again, that falls on the board. The board can appoint an investment committee to carry this out, but it's a good idea for boards of foundations that are managing assets like this to have an investment policy statement that's adopted by the board. Everyone understands what our investment policies are. It's going to outline things like your investment objectives, what's the roles and responsibilities of your outside investment managers versus maybe your internal investment policy or investment committee. It could lay out performance expectations for your investments, provides for your spending needs, and includes any prohibitions on investments. And this is getting a little more popular as we see foundations turning to or thinking about socially responsible investing. And in an investment policy statement, this is where you can outline kind of the do's and don'ts of your foundation. If you want to support socially responsible companies and maybe prohibit investments in other types of, for instance, tobacco firms or things like that, that's something you could adopt in your investment policy statement. So I mentioned an investment committee. You don't have to have an investment committee. Your board can be the investment committee, your entire board, but some foundations that have larger boards do like to appoint an investment committee. Some of the common duties of an investment committee are going to be the hiring or recommending of investment managers, interviewing those managers, creating an RFP or proposal process, supervising the engagement letter or the contract that you would have with your outside investment managers. Any agreement, we at the council strongly recommend that any agreement have the ability to terminate that relationship if you're not happy with it. There should never be a perpetual relationship with an outside investment manager. Ideally, you are going to have performance measurements, so you know if your hired investment manager is measuring up to your expectations, and also provide for appropriate fees. And I do want to stress that this kind of thing should be reviewed periodically. It doesn't have to be reviewed every year, but every few years you guys should look at your policy statements, at your agreements with your investment managers, reviewing them, making sure they reflect what's current in the industry and among foundations. And the council can help you with that as well. So now that hopefully everyone understands the duties of the board and the responsibilities, we're going to dig in a little bit to Internal Revenue Code Section 4944. So this is not a common section as far as foundations getting in trouble. There's not a lot of violations of 4944. But I think it's important to be aware, and as I said earlier, it's going to lead into a little bit of a discussion on program-related investing and mission-related investing. So to start with the background, 4944 is a pretty short section as well, and what it does is it imposes a penalty tax on any private foundation and the investment manager for amounts that are invested in a manner that jeopardizes the carrying on of the exempt purpose. So if you are investing in something that's particularly risky and it could jeopardize the amount of money you have available to grant and carry out your exempt function, that could be considered a Jeopardy investment. So a little bit more detail, according to the IRS, Jeopardy investments are generally investments that show a lack of reasonable business care and prudence. So going back to that standard of care that your board has, if things are entered into without reasonable research and deliberation and prudence in deciding to do this, considering your long-term and your short-term needs for the foundation, that is generally what the IRS views as a jeopardizing investment, although there's no single factor that's going to determine, yes, this is a Jeopardy investment or this is not. The Treasury regulations give us even more detail, and I've got the section up there, but it says basically an investment that jeopardizes carrying out of your exempt purpose is going to be determined if the foundation managers in making the investment fail to exercise ordinary business care and prudence, same kind of standard that we've been seeing. But this is important under the circumstances prevailing at the time of making the investment. So the decision on whether or not to enter into the investment is made at the time that the decision to make that investment. So it's not going to be judged years later on the results. It's at the time. At the time, something can seem very safe and very reasonable, and therefore you're probably going to be okay, even though later on it determines not to be a good investment. But again, looking at both the long-term and the short-term financial needs of your foundation. So you're obviously going to have investments that are geared toward long-term growth and to ensure your perpetuity of your foundation, but there are also going to be perhaps investments that are geared toward more short-term income if you know that you are looking at some large short-term grants or financial needs of the organization. So those factors will definitely be taken into consideration. So what are some examples? As the IRS says, there's no single category of investments that are just automatically Jeopardy investments, but they provide a list of things that are going to get, as they say, extra scrutiny. So you can see some of these items: securities on the margin and commodities futures, oil and gas wells have traditionally been on this list, buying puts and calls and straddles and warrants and selling short. These are the kind of things that they'll want to see extra deliberation, extra research before a foundation enters into these types of investments. I already kind of mentioned the timing on this, and timing does matter because, again, whether the investment jeopardizes the foundation's purpose is determined when the investment is made. So it could be perfectly reasonable and proper at the time. You know, everybody's doing it. It looks very safe. And then even though it may not turn out so great later on, it's what was prudent at the time. So here we've got some more factors to consider in deciding whether the investment of the amount jeopardizes your exempt purpose. You have to look at this investment by investment. I know, investment managers like to talk about the entire portfolio and balancing the portfolio, but for purposes of this section, you do look at each investment, and the penalty tax is assessed on that amount that you've invested in the Jeopardy investment. So you are looking at individual investments. But with that said, you are taking into account the foundation's portfolio as a whole. So we know that diversification requires a variety of investment strategies, from risky to super safe. And so looking at your portfolio as a whole, you may decide that you don't have enough risk and you are looking for something that may be a little bit more risky. So based on the portfolio as a whole, that may be a very reasonable decision. And then you drill down into the particular investment and say, okay, we understand that we're willing to invest some of our money in something that's a little bit more risky because it balances our portfolio and allows for some growth potential. But is this particular investment the right one for that level of risk? And that's what I mean when I say you look at each investment individually. So factors to consider: obviously your expected returns, the risks of rising and falling prices, and the need for diversification are all factors to consider looking at the portfolio as a whole, but then at each investment on whether or not it's prudent to enter into or approve that investment. Here's a note on the penalties that we're talking about under 4944. 10% of the invested amount that is paid by the foundation. So say you're making an investment of $100,000, 10% would be the penalty, and that is paid by the foundation. But then an additional 10% of the invested amount is paid by the investment manager, unless the investment manager's participation is not willful and is due to reasonable cause. So your outside investment manager could even have some liability here if he's participating in this kind of thing. The taxes can be assessed year after year as long as the investment is still in place. And there are additional taxes, as with so many of these revenue sections. Additional taxes are assessed if you don't correct the problem timely. So now I'm gonna pause for a second. I don't think we have any questions yet. We do have questions?
No questions yet.
No questions. Okay, awesome. All right. So now I'm going to get into a little bit of why this is kind of relevant right now, why we're really talking about it. As I said, the Section 4944, there's very few violations. Most private independent family foundations are very careful with their investment strategy. They hire great managers. They have smart people. And you will rarely find foundations that are violating 4944 or getting assessed any of the penalties under here. But in the last 10 years or so, as things like program-related investments and mission-related investing, as interest in that area has grown, there have been questions about how that fits in with this Jeopardy investment section of the code. And fortunately, in 4944, it's actually 4944C, there is an exception that states specifically that program-related investments are accepted from the Jeopardy investment penalties if the purpose of the investment is to accomplish a charitable purpose. So you are investing in a company because of what they do, and what they do is furthering your charitable purpose. And the code says that no significant purpose of the investment is the production of income or the appreciation of property. So you are truly making this investment because of what the company does. You're not doing it to look for production of income or appreciation of your stock shares. It's all about the charitable purpose, and this is very much like a grant-based approach. It's different from a grant because you are, whether you're doing it in the form of a loan or an equity investment, you're getting something in return or expecting to get something in return, unlike a grant. But the thought process is very similar to grant making in that you're looking at, does this further our charitable purpose? And of course, another difference with grant making is most of the time grants are made to other charitable organizations, whereas obviously program-related investing can be investing in for-profit companies as long as they're doing work that furthers your charitable purpose. We have further details in the Treasury regulations that you can find at 53.4944, and in fact we have specific examples of what can be a program-related investment. There's 18, I think, examples of different types of investments that will qualify under this program-related investing. And rather than go through them all, I'll just say that we have a very good explanation, and we have all of the examples outlined on our website, on a resource on our website that's titled Examples of Permissible and Impermissible Program-Related Investments. So it takes right from the Treasury regulations all of these different examples that are approved by the IRS as proper program-related investing. In fact, actually there were some new ones added just last year in April of 2016. The list grew, I think the list doubled with more examples because this is a growing field. A lot of foundations are entering into this, and you know, the more definite examples we have to go by, the better. Another thing that came out just a couple of years ago was this IRS Notice 2015-62. And this is interesting because you may be sitting back there saying, okay, wait a minute, I understand the program-related investing and investing in a company because it furthers our charitable mission. And, you know, let's take the example of a private foundation that's healthcare focused, right? Your mission is healthcare. And you are investing in maybe pharmaceutical startups because there's some companies developing some interesting new drugs that are going to help further your mission of improving healthcare for the people in the United States. So we've said that the program-related investment should be furthering your mission, so we can check that box and say, okay, we've got that covered. But then the next part of it was that you should not be going into this looking for a return on your investment or income or significant growth of your investment. And that naturally led to the question, would it be if you're doing both, if you're looking at the investment for your charitable mission, but also you expect a return on income or appreciation of your stock shares, is that then a PRI? Is it a program-related investment that would then be exempted from the requirements of Section 4944? So it's kind of a roundabout situation that you get yourself into. You don't meet the definition of program-related investing because you're failing the second part of it. you do expect a return on your investment. You do expect income or growth of your shares value. So it's not going to be a program-related investment for purposes of getting you out of 4944. But that's okay, and that's what this IRS Notice 2015-62 goes into. It's okay because if you are using your ordinary business care and prudence, you're not going to have to worry about the jeopardizing investment penalties. And we know that part of that prudence and that duty of care in decision making, one of the factors is the relationship of the investment to your charitable purpose. So the fact that you expect income from the investment or you expect a nice return on your investment, it's tied to your charitable mission. The purpose of it is to further your charitable mission. So in that way, and you use your prudence and care in deciding to enter into it, you're still going to be safe from the 4944 penalties, even though you're not technically a program-related investment. So I know, like I said, it's kind of a roundabout explanation, but you don't have, everything doesn't have to fit the exact definition of a program-related investment in order to be safe from 4944. And one other way that you can be safe, and this is kind of the sister to program-related investing, is mission-related investing. So mission-related investing is, I think, the term then that's used for this situation where you don't have a program-related investment because you are looking for returns, but you're investing because it furthers your mission. So that's mission-related investing. It's not program-related investments, but it's mission-related investing, and because it furthers your mission, and that's a primary factor in why you are entering into the investment, that can make up for more risk or the potential for loss or the lower returns, primarily the lower returns that you might expect from something like this. So that's the other side of the coin here, is that even if it's not a program-related investing, you may be mission-related investing, and that's okay because the IRS does recognize this tie to your mission as a valid reason and a valid factor of why you may want to invest in a particular company, even though from a strictly investment purpose or investment view, it may not be the most ideal investment for returns. So I hope that helps clarify. Now, I know we went through this pretty quick, and we're going to end up short of the hour that we had allocated, so I hope that's good news for everybody. Get a little bit of extra time in your day. But I do have a few final notes, and I want to check one more time with Talia to make sure if we have any questions.
Yeah, I do have a question, yes.
Oh, okay.
So do you want to go through your final notes, or do you want me to share the question?
Let me go through the final notes just in case that might answer it, and then we'll share the question. All right, so the first final note is a pretty easy to understand. Just because you may be accepted from 4944 does not relieve any person from complying with any federal or state laws, imposing an obligation, duty, or responsibility of conduct. So this goes back to the board's duty of care, and 4944, or rather the exception to 4944, particularly the program-related investment exception, is not just a get-out-of-jail-free card for boards to approve all kinds of risky investments. You still have to use that duty of care. You have to do your research. You have to get competent advisors and make these decisions carefully, and knowing that your primary loyalty lies to the foundation and the protection of its assets. The next final note says that this penalty tax on Jeopardy investments does not apply to investments originally made by a person who later transferred them as a gift to the foundation. So this can come up from time to time. You have a donor, maybe one of the founders of the foundation or someone else who wants to donate to the foundation, and they want to donate their stock or their interest in a business that if you had done it directly may be viewed as a Jeopardy investment, but because they've done it already and it's already in place and they are now giving it to you, the penalties in 4944 are not going to apply. However, if you pay compensation to that person in connection with the transfer of the investment, then it will be considered an investment made by your foundation, and you don't get to take advantage of this exception. And then I think this is the last of my final notes, which says taxes on Jeopardy investments does not apply to investments acquired by the foundation as a result of a corporate reorganization, nor does the tax apply to investments made before 1970. I'd be curious to know if anybody has investments made before 1970. I assume there are some out there, but that's just a final note about.
We probably should have took a poll.
That's true. We could put that poll feature in. Anyway, yeah. So I know, like I said, this is not a big section of the code. It's not a heavily enforced section of the code, or I don't want to say heavily enforced. It's not a section where there's a lot of instances of violations. So naturally, the information will be not as lengthy. So hopefully, everyone will appreciate the extra time we've got left over, but I do want to get to Talia and the questions that she's got.
Yeah, and it is regarding the PRI, MRI rules, but the question is, don't the PRI and MRI rules conflict with the requirement of UPMIFA?
That's a good question. So UPMIFA talks all about, protecting your endowment and investing prudently. UPMIFA, since it was updated, since when UPMIFA came out in the last 10 to 15 years or so, it was an update of UMIFA. It now provides more factors to consider, and it does state that one of the factors that you can consider when making investments and whether or not an investment is reasonable and prudent is the furtherance of your charitable mission. So I don't think there's really a conflict, and I don't know of any cases where a foundation has gotten in trouble at the state level under UPMIFA. Somebody brings a claim saying, you foundation, you violated UPMIFA because you've invested in something that's a little risky, if they have satisfied the program-related investing analysis. If they've gone through that and they say, well, we know it's risky, but it's going to help our charitable mission. It's important to further our charitable mission because that's one of the factors that UPMIFA allows. I think that would be your argument, would be like, well, we relied on this factor. Yes, we know it was a little riskier, but it was important for our mission. And I think UPMIFA will recognize that. That's the nice thing about UPMIFA, since it was updated, is that it really considers the whole picture of what a foundation is doing, and it's not so narrow focused on, are you picking the best and the most safest investments that have the highest returns. So yeah, I don't think I can see where the question came from, why there might look like a conflict, because UPMIFA is telling you to be very safe and be very prudent, and program-related investing and mission-related investing can sometimes seem a little less safe, but UPMIFA does recognize that tie to charitable mission.
Okay, I do, and I have one other question, and this is about hiring investment managers or consultants. Can you hire an investment manager or consultant that is related to one of the board members?
Okay, another good question, and that actually, you can say, you can look at 4944 or UPMIFA and say, are you the board, are you investment committee hiring the best manager that you can, and you can look at the qualifications and all of that and determine that this person is really the best investment manager for your foundation. But then you have to jump to section 4941, I think, the self-dealing section in the code. And then you have to look at the self-dealing rules. So now we're in a completely different section of the code. And because under the self-dealing rules, there are rules about a private foundation using its money, its assets, to provide benefits or to pay compensation to what's termed disqualified persons. So people that are related to the foundation, as donors, as board members, those insiders. So then you have to run through the self-dealing analysis and say, okay, this person is going to be considered a disqualified person. They're an insider. They're a board member, or the firm that they own, the investment firm they own is a related party. Can we still hire them? Obviously, it's a conflict of interest that the board would need to consider. But there are certain exceptions to the self-dealing rules which allow for compensation paid as long as it's reasonable and necessary to disqualified persons for certain professional services. And investment management is one of those professional services that you are allowed to pay a disqualified person to perform for your foundation if it's necessary, reasonable, and you've gone through the analysis of this is the best person, their track record is stellar, and their fee is way low. So, overall the situation says, yes, let's hire this person, and you can pay their fee or the compensation as an exception to the self-dealing rules. So that's a great question. It actually covers two different code sections. Yeah, that's the answer.
Okay. Well, we don't have any other questions, Suzanne,
okay.
but thank you so much for taking the time out to present, and thank those of you who decided to join us this afternoon. If you have any questions that come up after this, please don't hesitate to contact either Suzanne or I, and we will be in touch soon. Take care.
Thank you.